right, we are back. It's quite remarkable how many people private message me stating that watching these videos, gaining the acquired knowledge from Supreme Court cases and rulings, talking about jurisdiction and things, how they've been able to either overturn their case, completely stop it dead in its tracks, and have it vacated or dismissed. And it's been quite remarkable, the responses that I get from people that start to see a difference in the way that the public officials treat them once they start to utilize this knowledge for their benefit. And that's the reason that I do this. And if you enjoy what I'm doing, please join selfgovernance.com. That's SELFGOVERNANCE, the letter U.com. That helps support me to continue to do what I'm doing for you guys here. And I appreciate all your guys' support and words of encouragement and prayers. It does not fall on deaf ears, and I really appreciate you guys. If we're gonna fix this nation, it's gonna happen through an ascension of the mind, a higher education, if you will, and studying the right information, and critiquing it and curtailing it to our lifestyle. This is a life-altering decision that you must make if you're going to stand on the right side of history or not. Hey, Derek, stripping very common in this era of low-intensity biochemical warfare masquerading as flu. Yeah, I gotcha. Roger that. So anyway, we're going to continue on. I do these videos because I know a lot of people work a day-to-day life or live a day-to-day life through work. They work to live. They don't have time necessarily to read, but they do have time to listen to it as they work. And so I'm going to continue to do this as long as I can. Allodial land. Baker versus Dayton, 28 Wisconsin, 367, 1871. All lands within this state are declared to be allodial, and feudal tenures are prohibited. On this point, counsel contended first that one of the principal elements of feudal tenures was that the feudatory could not independently lien or dispose of his fee, and secondly, that the term allodial describes free and absolute ownership, independent ownership. In like manner as personal property is held, the entire right and dominion that it applies to lands held of no superior to whom the owner owes homage or fealty or military service, and describes an estate subservient to the purpose of commerce and alienable at the will of the owner, the most ample and perfect interest which can be owned in land. And I posted all this on my Facebook just a moment ago, so you guys have access to all of this. Bowers versus Diviat, or Divitu, U.S. Court of Appeals, 7th Circuit, 686F. 2D 616 1882. There is no constitutional right to be protected by the state against being murdered by criminals or madmen. It is monstrous if the state fails to protect its residents against such predators, but it does not violate the Due Process Clause of the 14th Amendment or, we suppose, any other provisions of the Constitution. The Constitution is a charter of negative liberties. It tells the state to let people alone. It does not require the federal government or the state to provide service, even so elementary a service as maintaining law and order. Income tax. Gregory versus Helverging, Helverging, 293 U.S. 465, 1935. The legal right of a taxpayer to decrease the amount of what otherwise would be his taxes, or altogether avoid them by means which the law permits, cannot be doubted. 1895, Pollock versus Farmers Loan and Trust Code, the Supreme Court rules that general income tax are unconstitutional because they are unapportioned direct taxes. Thus, to this day, the ruling has not been overturned. January 24th, 1916, the Bushaber, Brushaber versus Union Pacific Railroad, the Supreme Court ruled that the 16th Amendment doesn't overrule the court's ruling in the Pollock case, which declared general income tax unconstitutional. The 16th Amendment applies only to gains and profits from commercial and investment activities. The 16th Amendment only applies to excise taxes. The 16th Amendment did not amend the U.S. Constitution. The 16th Amendment only clarified the federal government's existing authority to create excise taxes without apportionment. The 16th Amendment contains nothing repudiating or challenging the ruling in the Pollock case that the word direct had a broader significance, since it embraced also taxes levied directly on personal property because of its ownership, and therefore the amendment, at least impliedly, makes such wider significance a part of the Constitution, a condition which clearly demonstrates that the purpose was not to change the existing interpretation except to the extent necessary to accomplish the results intended. That is, the prevention of the resort to the source from which a taxed income was derived, in order to cause a direct tax on the income to be a direct tax on the source itself, and thereby to take an income tax out of the class of excises, duties, and imposts and place it in the class of direct taxes. Indeed, in light of the history which we have given and of the decision in the Pollock case and the ground upon which the ruling in that case was based, there is no escape from the conclusion that the amendment was drawn for the purposes of doing away for the future with the principle upon which the Pollock case was decided, that is, of determining whether a tax on income was direct not by a consideration of the burden placed on the taxed income upon which it directly operated, but by taking into view the burden which resulted on the property from which the income was derived. Since in express terms the amendment provides that income tax from whatever source the income may be derived shall not be subject to the regulation of apportionment. In 1939, Congress passes the public salary tax, taxing the wages of federal employees. In 1940, Congress passes the Buck Act, authorizing federal government to tax federal workers living in the state. In 1942, Congress passes the victory tax under constitutional authority to support the World War II effort. President Roosevelt proposes a voluntary tax withholding program allowing workers across the nation to pay the tax in installments. The program is a success, and the number of tax payers increases from 3% to 62% of the U.S. population. In 1944, the victory tax and voluntary withholding laws are repealed as required by the U.S. Constitution. However, the federal government continues to collect the tax, claiming its authority under the 1913 income tax and the 16th Amendment. Erie Railroad versus Tompkins in 1938, Supreme Court of the United States had decided on the basis of commercial negotiable instrument law that Tompkins was not under any contract with the Erie Railroad and therefore had no standing to sue the company. Under the common law, he was damaged and he would have had the right to sue. Hence, all courts since 1938 are operating in an admiralty jurisdiction and not common law courts, because lawful money, silver or gold coin, does not exist. Courts of Admiralty only has jurisdiction over maritime contracts on the high seas, navigable waters, ways. In Blockberger versus U.S. 284, U.S. 299, 1932, the Supreme Court held that the punishment 4. The statutory offenses arising out of the same criminal act or transaction does not violate the double jeopardy clause if each provision requires proof of an additional fact which the other does not. ID at 304. Boyd versus United States 116, U.S. 616 at 635 in 1885. Justice Bradley, it may be that it is the obnoxious thing in its mildest form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approach and slight deviations from legal modes of procedure. This can only be obviated by adhering to the rule that constitutional provisions for the security of persons and property should be liberally construed. A close and literal construction deprives them of half their efficiency and leads to gradual depreciation of the rights, as if it consisted more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachment thereon. Their motto should be obsta principiis. Downs versus Bidwell, 182 U.S. 244, 1901. It will be an evil day for American liberty if the theory of a government outside supreme law finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of the principles of the Constitution. Dukin versus Missouri, 152 U.S. 377, 382, 1894. Due process of law and the equal protections of the law are secured if the laws operate on all alike and do not subject the individual to an arbitrary exercise of the powers of government. Gizzo, Giozza versus Tiernan, Tiernan, 148 U.S. 657, 662, 1893. Citations omitted undoubtedly at the 14th Amendment. Forbids any arbitrary deprivation of life, liberty, or property, and secures equal protection to all under like circumstances in the enjoyment of their rights. It is enough that there is no discrimination in favor of one as against another of the same class, and due process of law within the meaning of the Fifth Amendment is secured if the laws operate on all alike and do not subject the individual to an arbitrary exercise of the powers of the government. Kentucky Railroad Tax Case 115 U.S. 321, 337, 1885. The rule of equality requires the same means and methods to be applied impartially to all the constituents of each class, so that the law shall operate equally and uniformly upon all persons in similar circumstances. Butts versus Economou, ECONOMOU, 98 SCT 2894, 1978. United States versus Lee, 106 U.S. at 221, SCT at 261, 1882. No man or woman in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. Olmstead versus United States, 1928, 277 U.S. 438. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. Malloway versus Hogan, 378 U.S. 1. All rights or safeguards contained in the first 8 amendments to the federal Constitution are equally applicable. U.S. versus Lee, 106 U.S. 196, 220, 1 SCT 240, 261, 27 LED 171, 1882. No man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and bound to obey it. It is the only supreme power in our system of government, and every man who, by accepting office, participates in its function is only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes on the exercise of the authority which it gives. Albleman versus Booth, 21 Howard, 506, 1859. No judicial process, whatever form it may assume, can have any lawful authority outside of the limits of the jurisdiction of the court or judge by whom it is issued, and an attempt to enforce it beyond these boundaries is not less than lawless violence. Is nothing less than lawless violence. Stump versus Sparkman, ID 435 U.S. 349. Some defendants urge that in any act of judicial nature entitles the judge to absolute judicial immunity, but in a jurisdictional vacuum, that is, absence of all jurisdiction, the second prong necessary to absolute judicial immunity is missing. A judge is not immune from tortious acts committed in a purely administrative, non-judicial capacity. Marbury versus Madison, 5 U.S.C. 2 Cronch, 137, 180, 1803. The particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. In declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. The law, rules, and practices which are repugnant to the Constitution are void. Since the 14th Amendment, the Constitution states, no state jurisdiction shall make or enforce any law which shall abridge the rights, privileges, or immunities of the citizens of the United States, nor deprive any citizen of life, liberty, or property without due process of law or equal protection under the law. This renders judicial immunity unconstitutional. Piper versus Pearson, 2 Gray 120, cited in Bradley versus Fisher, 13 Wall 335 20 LED 646 1872. Where there is no jurisdiction, there can be no discretion, for discretion is incident to jurisdiction. Chandler versus Judicial Council of the 10th Circuit, 398 U.S. 7490 SCT 1648 26 LED 2D 100 Justice Douglas. In this dissenting opinion at page 140 said, if federal judges break the law, they can be prosecuted. Justice Black, in his dissenting opinion at page 141, said, judges, like other people, can be tried, convicted, and punished for crimes. The judicial power shall extend to all cases in law and equity arising under this Constitution. Davis versus Burris, 51 Arizona, 220-75, page 2D 689, 1938. A judge must be acting within his jurisdiction as to subject matter and person to be entitled to immunity from civil action for his acts. Jurisdiction, once challenged, cannot be assumed and must be decided. Maine versus Thibodeau, 100 SCT 250. U.S. versus Dixon, 113 SCT 2849, 2856, and 1993. The court clarified the use of the same elements test set forth in Blockberger when it overruled the same conduct test announced in Grady versus Corbin, 495 U.S. 508, 1990, and held that the double jeopardy clause bars successive prosecution only when the previously concluded and subsequently charged offense failed the same elements test articulated in Blockberg. See also Gaviers versus U.S. 220 U.S. 338, 345, 1911, early precedent establishing that in the subsequent prosecution, while it is true that the conduct of the accused was one and the same, two offenses resulted, each of which had an element not embraced in the other. Judicial immunity. See Judicial Immunity page for more citations, links, and news articles regarding the topic. See also Title 42 U.S.C. 1983, Availability of Equitable Relief Against Judges. Note, copied verbiage, we are not lawyers. Judges have given themselves judicial immunity for their judicial function. Judges have no judicial immunity for criminal acts, aiding, assisting, or conniving with others who perform a criminal act, or for their ministerial duties, or for violating a citizen's constitutional rights. When a judge has a duty to act, he does not have discretion. He is then not performing a judicial act. He is performing a ministerial act. Now, nowhere was the judiciary given immunity, particularly nowhere in Article 3 under the Constitution. If judges were to have immunity, it would only possibly be granted by amendment, and even less possibly by legislative act, as Article 1, Section 9 and 10, respectively, in fact, expressly prohibit such stating, no titles of nobility shall be granted by the United States, and no state shall grant any title of nobility. Most of us are certain that Congress itself doesn't understand the inherent lack of immunity for judges. Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts shall hold their offices during good behavior. Tort and Insurance Law Journal, Spring 1986, 21 in 3, page 509 through 516, Federal Tort Law. Judges cannot invoke judicial immunity for acts that violate litigants' civil rights. Robert Craig Waters. English Tort Law, 61, Ashby versus White, 1703, 92, ENG, period, rep. 126 KB Blackstone Supra, note 59 at 23, 62, 5 U.S. 1 Cronch 137, 163 through 66, 1803. It is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law, whenever that right is invaded, or it is a settled and invariable principle in the laws of England that every right, when withheld, must have a remedy, and every injury its proper redress. English Tort Law, Ashby versus White, 1703, 92, England report. Facts. Mr. Ashby was prevented from voting at an election by the misfeasance of a constable, Mr. White, on the apparent pretext that he was not a settled inhabitant. At the time, the case attracted considerable national interest and debates in Parliament. It was later known as the Ashbury election case. In the Lords, it attracted the interest of Peter King, 1st Baron King, who spoke and maintained the right of electors to have a remedy at common law for denial of their votes against Tory insistence on the privileges of the Commons. Sir Thomas Powys, c. 1649 through 1719, defended Williams White in the House of Lords. The argument submitted was that the Commons alone had the power to determine election cases, not the courts. Judgment. Holt C.J. was dissenting in this judgment in the High Courts, but this was upheld by the House of Lords. He said at page 273-4, if the plaintiff has a right, he must of necessity have a means to vindicate and maintain it, and a remedy if he is injured in the exercise of or enjoyment of it. And indeed, it is a vain thing to imagine a right without a remedy. For want of right and want of remedy are reciprocal. And I am of the opinion that this action on this case is a proper action. My brother Powell indeed thinks that an action on the case is not maintainable because there is no hurt or damage to the plaintiff. But surely every injury imports a damage, though it does not cost the party one farthing, and it's impossible to prove the contrary, for a damage is not merely pecuniary, but an injury imports a damage, when a man is thereby hindered of his rights. To allow this action will make public officers more careful to observe the constitution of cities and boroughs, and not to be so partial as they commonly are in all elections, which is indeed a great and growing mischief, and tends to the prejudice of the peace of the nation. Collection of the court authorities in regards to the District Court of the United States by Paul Andrew Mitchell, B.A., M.S., all rights reserved. We begin with one of the great masters of Constitution, Chief Justice John Marshall, writing in the year 1828. Here, Justice Marshall makes a very clear distinction between judicial courts authorized by Article 3 and legislative territorial courts authorized by Article 4. Marshall even utilizes some of the exact wording of the Article 4 to differentiate those courts from Article 3 judicial power courts as follows. These territorial courts, then, are not constitutional courts in which the judicial power conferred by the Constitution on the general government can be deposited. They are incapable of receiving it. They are legislative courts created in virtue of the general rights of sovereignty which exist in the government, or in virtue of that clause which enables Congress to make all needful rules and regulations respecting the territory belonging to the United States. The jurisdiction with which they are invested is not a part of that judicial power which is defined in the third article of the Constitution, but is conferred by Congress in the execution of those general powers which that body possesses over the territories of the United States. Although admiralty jurisdiction can be exercised in the state in those courts only which are established in pursuance of the third article of the Constitution, the same limitation does not extend to the territories. In legislating for them, Congress exercises the combined powers of the general and of the state government. American Insurance Co. versus 356 bales of cotton, 1 Pete 511, 1828, emphasis added. Though the judicial system set up in the territory of the United States is part of the federal jurisdiction, the phrase Court of the United States, when used in a federal statute, is generally construed as not referring to territorial courts. See Balzac versus Puerto Rico, 258 U.S. 298 at 312, 1921, 42 SCT 343, 66 LED 627. In Balzac, the High Court stated the United States District Court is not a true United States court established under Article 3 of the Constitution to administer the judicial powers of the United States therein conveyed. It is created by virtue of the sovereign congressional faculty granted under Article 4, Section 3 of that instrument of making all needful rules and regulations respecting the territory belonging to the United States. The resemblance of its jurisdiction to that of true United States courts in offering an opportunity to non-residents or resorting to a tribunal not subject to the local influences does not change its character as a mere territorial court. Balzac versus Puerto Rico, 258 U.S. 298 at 312, and 42 SCT 343 66 LED 627 1921. Constitutional provisions against diminution of compensation of federal judges was designed to secure independence of judiciary. Allodial versus U.S. 289 U.S. 516 1933. 2. Headnote, Judges. The term District Courts of the United States, as used in criminal appeals rules, without an addition expressing a wider connotation, had its historic significance and described courts created under Article 3 of the Constitution and did not include territorial courts. Mukini et al. Versus U.S. 303, U.S. 201, Headnote 2 courts, emphasis added. Where statutes authorize Supreme Courts to prescribe criminal appeals rules in district courts of the United States, including named territorial courts, omissions in the rules when drafted of reference to district courts of Hawaii and certain other of the named courts indicated that criminal appeal rules were not to apply to those latter courts. Mukuni et al. Versus U.S. 303, U.S. 201, Headnote 4 courts, emphasis added. The following paragraph from Mukuni is extraordinary for several reasons. One, it refers to the historic and proper sense of the term district courts of the United States. Two, it makes a key distinction between such courts and applications of their rules to territorial courts. Three, the application of the maxim inclusio unis est exclusio ulterius is obvious here. Namely, the omission of territorial courts clearly shows that they were intended to be omitted. Not only did the promulgating order use the term district courts of the United States in its historic and proper sense, but the omission of provisions for the application of the rules to the territorial courts and other courts mentioned in the authorizing act clearly shows the limitation that was intended. Mukini et al. Versus U.S. 303, U.S. 201, emphasis added. The words District Court of the United States commonly describes constitutional courts created under Article 3 of the Constitution, not the legislative courts which have long been courts of the territories. International 1, Longs, Herms, and Warehouseman's Union et al. Versus Juna Spruce Corp. 342 U.S. 237, 1952, emphasis added. The phrase, Court of the United States without more means, solely courts created by Congress under Article 3 of the Constitution are not territorial courts. International Longhorns and Warehousemen's Union et al. Versus Wirtz, WIRTZ, 170 F2D 183, 9th Circuit, 1948. Head note, emphasis added. United States District Courts have only such jurisdiction as is conferred by an act of Congress under the Constitution. USCA Constitution, Article 3, Section 2, Title 28, USCA 1344. Hubbard versus Merriman, 465 F2D 1169, 5th Circuit, 1972. Head note, the United States District Court are not courts of general jurisdiction. They have no jurisdiction except as prescribed by Congress pursuant to Article 3 of the Constitution. Many cites omitted. Graves versus Sneard, 541 F2D 159, 6th Circuit, 1976. The question of jurisdiction in the court, either over the person, the subject matter, or the place where the crime was committed, can be raised at any stage of a criminal proceeding. It is never presumed, but must always be proved, and it is never waived by a defendant. U.S. versus Rogers, 23 F. 658, D.C., Arkansas, 1885. In a criminal proceeding, the lack of subject matter jurisdiction cannot be waived and may be asserted at any time by collateral attack. U.S. versus Journey, 228 F. Superior Court, 329 D.C.NY, 1964. Jurisdiction of courts may be challenged at any stage of the proceeding and also be challenged after conviction and execution of judgment by way of writ of habeas corpus. U.S. versus Anderson, 60 F. Superior, 649 D.C. Wash, 1945. The United States District Court has only such jurisdiction as Congress confers. Eastern Metal Corp versus Martin, 191 F. Superior Court, 245 D.C. NY, 1960. U.S. versus Halper, 490 U.S. 435, 440, 1989. Double jeopardy being tried twice for the same offense prohibited by the Fifth Amendment to the U.S. Constitution. The double jeopardy clause protects against three distinct abuses. 1, a second prosecution for the same offense after acquittal. 2, a second prosecution for the same offense after conviction. And 3, multiple punishments for the same offense. 2 Am Jurisprudence 2D, page 129, 1962, Administrative Law, Section 301, particular applications and applications of the principles that the power of an administrative agency to make rules does not extend to the power to make legislation, and that a regulation which is beyond the power of the agency to make is invalid. It has been held that an administrative agency may not create a criminal offense or any liability not sanctioned by the lawmaking authority, and specifically a liability for a tax, or inspection fee. Bold emphasis added. Footnote: 2 Commissioners of Internal Revenue versus Acre, 361 U.S. 87 4 LED 2D 12780 SCT 144 1959. Roberts versus Commissioner of Internal Revenue Service 176 F2D 221 10 ALR 2D 186 9th Circuit 1949. Regulations can add nothing to income as defined by Congress, citing me M.E. Blackco versus United States 305 U.S. 267 279 59 SCT 186 190 83 LED 167 1938. Independent Petroleum Corp versus Fly 141 F2D 189 152 ALR 928 5th Circuit 1944. The power to make regulations does not extend to making taxpayers of those whom the act properly construed does not tax. Indiana Department of State Revenue versus Colpater Realty Corp. 231 Indiana 463 109 NE2D 415. No power to render taxable a transaction which the statute did not make taxable. Morrison Knudsen Co. versus State Tax COM 242 Iowa 3344 NW 2D 449 41 ALR 2D 523. Use tax. Liability for the payment of the sales tax is controlled by statute. It cannot be controlled by ruling or regulation of the board. Akron Iron Workers versus State Board of Tax Administration 295 Michigan 143 295 NW 126 139 ALR 368 annotation 139 ALR 380 retail sales. City of Canton versus Harris 498 U.S. 378 1989. Failure to training its officers adequately with respect to implementing the following department policies. Decisions for rights to travel. Dear law enforcement officers, with all due respect, demand for trial by jury to first decide the innocence or guilt of this individual upon the instant matter is hereby made on all proceedings arising from charges made by the officer or department of the government. Demand that nature and cause be proven into the record of the court for any charges arising from charges made by this officer or department of government is hereby demanded. Please attach this document in its entirety with any charge, summons, or information you may make regarding me, as this document constitutes a specific demand for jury trial to first decide my innocence or guilt, and that the nature and cause for said charge be proven in this or any matter arising out of this matter, and that it must be made a part of this record of any and all proceedings as my communication to the court, and as these demands are fully supported by the Sixth Amendment to the Constitution of the United States of America, the law of the land, all others notwithstanding. I am hereby informing you that I do not consent to talk to you, and that I must insist, unless you are placing me under arrest or can state specific and articulable facts which warrant your detaining me, that you immediately leave me alone to go about my business, as is my right as a United States citizen. I am engaged in the ownership and use of property belonging to me as I see fit to use it, and is my constitutional right to do so. My responsibilities to that act does not extend beyond any harm my decision does to another. If you, the officer or applicable department of government, are attempting to curtail my free use of my property, you are hereby requested to identify the injured party and to instruct said injured party to articulate the specific harm I or myself use of my property has caused, in writing, and provide it to me and to the applicable court. Should you choose to ignore this request and to detain me or cause me costly litigation, knowing that no injured party exists as a result of my actions, be advised you are very likely acting outside your authority of your office and your sovereign immunity. I am not operating a motor vehicle pursuant to Title 18, Part 1, Chapter 2, 31, Definitions, 6, Motor Vehicle. In terms, motor vehicle means every description of a carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of the passengers and property, or property for or cargo. Whereas I recognize it is your charge to protect the safety and welfare of the citizenry, you must also see that I have not harmed nor caused to be harmed anyone. I state here and now that I have exercised my unalienable rights in a fashion that is within the meaning and protection of the U.S. Constitution, and beyond that, I have no responsibility. In addition, as it is my opinion, this detention is completely about converting my money to the use of this municipality, city, county, and or state. I inform you that my property is also protected by the Constitution, just mentioned, and that my money is my property. I do not choose to surrender it, nor any other right protected for me by that Constitution, nor could I, if I did so choose. In addition, be advised that any act on your part to proceed under color of law against me, knowing full well I am not party to a contract which enables you to enforce traffic and property laws, unless there is a real, true injured party willing to testify that I have done them harm, will be met with an aggressive and protracted and time-consuming court battle before a jury of my peers. I am party to no contract, visible or invisible, with corporate body politics in the city of Clinton, county of Clinton, state of Iowa, or any other city, county, state in the union or the federal government. In clarification, I pay for a few services supplied by this government that I use with money. The legal tender of this land, i.e. income tax, fuel tax, cigarette tax, sales tax, property tax, real estate tax, etc., 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 I do not pay with my rights, as do most others Americans. Beyond that payment, I am not indebted to this or any other government entity. As such, there can be no valid contract, visible or invisible, which binds me to the laws by contract you are heretofore attempting to enforce. I have no history of physical violence and am thereby no threat to your safety, as that fact will not change now. In addition, any assumed contracts this court or this city may be acting in accordance with have been rescinded from their inception per affidavit currently. I was acting within my right within respect to the use I made of my property, as is defined in Spann versus City of Dallas, Texas, SC 1921, and or I was exercising my constitutional rights to travel in an automobile as pointed out in Chicago Motor Coach versus Chicago Quoted 169 NE 221, which says, use of the highway for purposes of travel and transportation is not a mere privilege, but is a common and fundamental right of which the public and individuals cannot be deprived. Highways are for the use of the traveling public, and all have the right to use them in a reasonable and proper manner. The use thereof is an inalienable right of every citizen. Escobodio versus State 35 CTD C2D 870 and 8 California Jurors 8 Cal Juror 3D page 27. User of the highway for transportation of persons and property for hire may be subjected to special regulations not applicable to those using the highways for public purposes. Richmond Banking Co. versus Department of Treasury 18 NE 2D 788. The use of an automobile as a necessity adjunct to the earning of a livelihood in modern life requires use in the interest of realism to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees. Berberian versus Lucier, 1958, 139, A2D, 869, 872. And when we come back, we'll finish this up. We're so close. Thanks for joining me.